just start by thanking the Journalists and Writers Foundation for this opportunity to present, but more importantly, for the opportunity to hear so many voices share their visions for a better future. I intend to address the rule of law as a constitutional concept in the internal government of nation states. I'm not going to talk about the rules-based international order, although global tensions threaten both in a very similar way. Those tensions radiate out from the fault line between the world's two economic powers, the United States and China, in their competition for global hegemony. The fallout adversely affects both superpowers as well as developed and developing countries around the world by undermining their national economies, the living standards of their people, and their sovereignty. Historically, it's not surprising that in a period of existential threats, many look to demagogues and authoritarians for their salvation. Nations around the world are riven by bitter divisions which threaten, as James has mentioned, democracy and the rule of law. But let me first quickly trace the history of our liberal democratic tradition and the related principles of the rule of law and the independence of the judiciary. The democratic government adopted by ancient Athens was exercised directly by its citizenry and not mediated through parliamentary representatives. It was radically participatory, but it was not a liberal democracy. It recognised only one of what we now know as human rights, and that's the right to free speech. Pericles, in his famous funeral oration, explained it in this way: "We Athenians subject our decisions on policy to proper discussion, for the worst thing is to rush into action before the consequences are properly debated." Athens' participatory democracy extended to the administration of the law. Legal claims were determined by juries comprising upward of several hundred citizens who cast their decisions by ballot in accordance with the orator who most appealed, usually to their reason, but all too often to their passion and biases. However, in the same period, a concept of justice closer to ours was being conceived. The Aristotelian ideal is that the law be governed by reason and morality, unaffected by passion. Aristotle warned that the direct administration of the law by the sovereign, even if it be an assembly of citizens, allowed passion to pervert the reason of even the best rulers. The just resolution of disputes is a deeply rooted human need. It's the cornerstone of the social contract. The Aristotelian ideal has been passed down through religious precepts and philosophical thought. Think of the fourth beatitude: "Blessed are those who hunger and thirst for justice, for they shall be filled." And Leviticus: "Do not pervert justice, do not show partiality to the poor or favoritism to the great," commands which still find voice in judicial oaths to this day. However, the constitutional adoption of the Aristotelian ideal was many centuries in the making. The 17th century was an era of great turmoil in England. James II was crowned in 1865, but was deeply unpopular by 1868. He ruled by decree, dismissed judges who disagreed with him, and fomented religious and political divisions. All this in a period of shifting European alliances. It sounds all too familiar. Fearing a return to civil war, the Dutch Prince, William of Orange, was invited by the Parliament to invade England and save the nation. He ruled in collaboration with the Parliament in a way which laid the foundation for what has become the Westminster form of democratic and constitutional monarchy. Importantly for what I'm addressing today, in 1701, the Parliament, with William's assent, passed the Act of Settlement, which provided that judges would retain their office for life unless removed by both houses of Parliament for misbehaviour. By that act, the monarch's power to control the judiciary by threats, punishment or dismissal was abrogated forever. Montesquieu, the French philosopher, based his treatise, The Spirit of Laws, on that legislated separation of powers. He argued that there is no liberty if the power of judges be not separated from the legislative and executive powers, because the life and liberty of the subject would be exposed to arbitrary control. But Montesquieu did not favour the establishment of an institutionally independent judiciary appointed from the ranks of preeminent jurists. To this day, the inquisitorial courts of civil law jurisdictions comprise university graduates trained to be judges and not lawyers, organised like other departments of state with promotion and leadership positions of short tenure decided by the executive government, features which make those courts more vulnerable to executive interference, a trend which has emerged more strongly in Europe since 2010, including the Polish muzzle law of 2019. Judges remain in prison to this day as a result of repressive measures taken in Turkey since 2016, all civil law jurisdictions. The English jurist Blackstone agreed that the public's liberty could only be preserved by a distinct separate existence of the judicial power, but only if it was exercised by a corps of independently minded judges, learned in the law, who are institutionally self-managed, nominated by the Crown, but not removable at its pleasure. Blackstone's view was undoubtedly influenced by the historical fact that the English common law was developed by judges who studied judicial precedents and applied them coherently, whereas on the other hand, the civil law jurisdictions courts administered legislated codes. On either approach, the judiciary is, as Hamilton wrote, from the nature of its functions, the least dangerous to the political rights of the Constitution, having neither force nor will, but merely judgment. A former Australian Chief Justice explained or explicated that theme when he said that the judiciary has public confidence as its necessary and sufficient power base. It does not have, nor does it need, the power of the purse or the power of the sword to make the rule of law effective, provided that the people whom it serves have confidence in the exercise of the power of judgment. At the close of the 20th century, many were celebrating what was called the end of history and the dawn of a liberal democratic eternity. The rule of law and an independent judiciary were proclaimed as the gold standard for all nations to follow. Liberal democratic constitutions guaranteed an ever-increasing range of human rights protected by an independent judiciary. The autocrat ruling by decree was relegated to history, or so it seemed. Well, history's wheel did not stop turning. Global tensions and domestic crises are back. However, whereas the crises in the 17th century in England gave birth to liberal democracy and the aftermath of World War II to a rules-based international order centred around the United Nations, opposing reactionary forces are at work today. Divisions within nations are deep. Political rhetoric can be hateful and even violent. Aggressive majoritarianism of that kind threatens both human rights and the legitimacy of an independent judiciary. Traditional and social media now pass judgment before trial without hearing both sides in a perversion of the Athenian jury, or they condemn the decisions of judges not caring to inform themselves of the law or the facts. Growing numbers of sovereign citizens who refuse to recognise any legal authority clog up the courts with pseudo-law. Some governments anticipate constitutional obstacles to their agendas by appointing judges whom they believe will support their political program, trashing the accepted constitutional convention that only those who are most skilled and most independently minded will be appointed judges. Some judges exacerbate that problem by not distancing themselves from political parties to which they are sympathetic. Watching from Australia, where constitutional conventions remain robust, the references in other places, the frequent references in other places to the political party that appointed the judge when reporting court decisions is deeply disturbing. The capacity or even the will of political leaders to mend their ways, at least in the short term, is questionable, It's of first importance, therefore, that judges adhere strictly to the judicial method and continue to fully explain their reasoning in their judgments. They must not sit in cases where there is an apprehension of bias. They must distance themselves from the politically and financially powerful. They must model respectful behaviour which recognises the equal human dignity of all people. Most importantly, the judiciary and the legal profession must show themselves to be servants of the public by substantially expanding timely and cost-effective access to courts so that wrongs are remedied. If the courts don't satisfy the public's thirst for justice, then the public will see no value in the independence of the legal system and have no reason to defend it when it is threatened by powerful interests. But let me finish by making it clear that I remain, despite the gathering clouds, deeply optimistic that good people standing firm will prevail over authoritarianism. I think symbolism is extremely important and having models is important, and that is one of the tragedies of the crises in the Western developed countries, that they can't serve that. We did a tour yesterday around the Statue of Liberty. That for a long time has symbolised and was a symbol of America's independence and a fair society. So it's a great crisis. Perhaps the answer is that countries around the world look internally at their strengths and their model of democracy. I think at the heart of your question is the problem, or is the difference between democracy and liberal democracy, and what I've described as aggressive majoritarianism, because the fact is that once a party has the majority in the legislature, it can make laws which are oppressive and repressive against all the conventions towards expanding human rights which we've had until now. So rule by law, if you take a positive view of the law, means that judges just must enforce the law as it is. Rule of law goes more to the constitutional conventions and laws which prevent direct interference. The legal method is to find the facts and apply the law as it is. But there does come a critical point where the laws are so repressive, and we can think about apartheid South Africa, we can think about Nazi rule in Germany, where the only answer that there is to resign and not be involved in the application of those laws, which are so repressive, at great personal cost. And unfortunately, it's not a good answer, because people who resign, as I think might be the case, for example, with some prosecutors who've resigned in the United States recently, are often replaced by people who are less able and less ethical. But ultimately, that's the only thing that people with ethical values can do. For your existing judges, the way they can take a stand is ultimately resignation, and your prosecutors. But the other questions are largely political. And I think that Michael you were going to speak on the ability of multilateral agreements and arrangements to bring pressure on countries. Unfortunately, it seems to me that's failing for the reasons that there is no longer a beacon of democracy and liberal democracy. But Michael and Arfa might have something to say about those things more than I can say.